Watching us today are two civil attorneys, Jeffrey Steinberger and Andrew Smiley. I'm going to ask both of you to stand by, but first I should add, great to have you with us this morning. Right now, though, we're going to go right into the courtroom, and this is the defendant, the doctor at the center of this. About 1995, this is pre-Terry Schiavo, the right to die case in Pennsylvania. This is pre-Jack Kevorkian, who some have called the doctor of death, pre him being convicted in a case where he was saying he was helping someone to die. In other words, were the rules really confusing back in 1995? Was a living will enough, and advance directives?
And Dora, not only were they confusing back then, they're confusing right now. They are murky, they're cloudy, they got to be very specific. Look, a DNR has to be only for defibrillation after cardiac arrest. That's it. Period. All other methods it's fair game. You could do IVs, you could do blood tests, you could do Chem 7s, you could do stats, you could do intubation, you could do all that stuff. The problem here in this advance directive that she had, this doc had to make a decision 40 minutes out when he couldn't assess her. So who do you want to call this? You want the nurse at her nursing home to say, let's kill her. You know, without the doc assessing it and saying, let me do an evaluation, let me make sure that it's not something that maybe she's sleeping, maybe she's in a slight epileptic seizure, maybe she's in a med reaction. You know, this is a very tried area. Right. This is a very difficult area to make decisions in, and it's so hard for this doc to make that decision and call a death. This is a human being's life that's at stake, and to call it 40 minutes out without even...
Jeffrey Steinberger, what does this case boil down to, and what can we learn from it?
Dora, we don't want our doctors being lawyers. We certainly got enough lawyers out there, and we certainly don't want a doctor to be a lawyer.
No, you're kidding, right?
Yeah, I think we got much too much lawyers out there, right. So what we need is the doctor not to sit and ponder the legal issues. Look, end-of-life decisions are really tough, but we don't want our doctor to sit and worry whether he's going to get sued in the middle of an emergency and sit and think what the case law is. We want him to act, and we want him to act fast, and we want him to act now. End-of-life decisions are tough. They're difficult decisions even for us lawyers, and we don't want a medical physician having that burden to think about those things, think about case law, being confused, and dwell on this issue.
But, Andrew Smiley, let's get you in here on this conversation. But at what point should they be?
Because the doctor made a good witness and say, listen, it's your job to carry out our desires.
Jeffrey, your final thought here?
Dora, the doc did everything possible in his medical practice to treat this patient with dignity and make sure that she was preserved and that her end-of-stage life
So your prediction is the jury won't find him responsible, the doctor?
I don't think the doctor's going to get nailed at all. I think the doctor did everything right. I think he did exactly what his medical treatment and medical training taught him to do. I think the course and scope of the care...
I'm sorry, Jeffrey, we could go on forever and ever.
We sure could.
The three of us could, but unfortunately my time is wrapped up with you today. Thanks to Jeffrey Steinberger and Andrew Smiley, both of you, for your insights into the case.